Hi, welcome back to my channel. Please like, comment, and subscribe. The attorneys at Tripp and Bird LLC are some of the nation's most experienced maritime injury lawyers. For the past 30 years, they have devoted their legal practice to representing injured seamen in claims under the Jones Act and federal maritime law. They have recovered millions of dollars in compensation for their clients. The partners at Tripp and Bird LLC have handled thousands of maritime injury claims. We know the Jones Act. The Jones Act is a federal statute that provides compensation to seamen and fishermen who are injured through the negligence of their employer. Federal maritime law is designed to protect the injured seamen, fishermen, and maritime workers. It is a right given to seamen by law. The Jones Act, combined with the general maritime law, provides injured workers the ability to get fair and complete compensation for their on-the-job injuries. To get fair compensation in serious injury cases involves a thorough investigation of how your injuries occurred and understanding how your injuries will impact your employment and future enjoyment of life. Under the Jones Act, an injured seaman or fisherman is entitled to a jury trial and has the right to file his suit in federal or state court. The Jones Act protects and provides benefit to all workers aboard a vessel that contribute to its mission, including cooks, deckhands, engineers, mates, and masters. It is the rule under federal maritime law that fish processors who work on vessels that go to sea are covered employees under the Jones Act. In most cases, the Jones Act provides greater benefits to injured fish processors than state workers' compensation systems. It is critical that employers provide proper training and safe equipment to prevent fish processors from being injured at work. Determining the fair value of compensation for your injury. In almost all cases, an injured seaman is entitled under the maintenance and cure doctrine to have his injury-related medical expenses paid and also to receive a daily living allowance. In addition to these benefits, under the Jones Act, a seaman injured through the negligence of his employer or fellow crewman is entitled to compensation for pain and suffering, disfigurement, lost wages, future lost wage earning capacity, vocational retraining expenses, loss of enjoyment of life, and future medical expenses. Attempting to determine the fair value of compensation that should be paid to a Jones Act seaman involves weighing multiple factors. To receive compensation under the Jones Act, the seaman is required to prove that his employer was negligent. The Jones Act requires an employer to provide the seaman with a safe place to work, the proper tools and equipment to do a job, and an adequate number of crewmen to do an assigned task. Almost all injuries at sea can be prevented if proper safety procedures are followed. Do not accept blame for a maritime injury accident that is not your fault. The Jones Act contains special provisions that void and contractual language, decide of regulations that attempt to prevent an injured seaman's right to claim compensation. If your employer violates a safety regulations that contributes to your injury, the employer may not be able to claim any comparative fault as a defense to your claim. We know the fishing industry and the law. An injured seaman or fisherman should never guess about whether or not he has the right to compensation under the Jones Act. When injured, the seaman should consult an experienced maritime lawyer as soon as possible to learn about the rights and benefits he may have under the Jones Act. Please do not accept blame for a maritime injury accident that is not your fault. Also, never sign a release of your right to compensation without first discussing your maritime rights with an experienced Jones Act and maritime law injury lawyer. The Jones Act is an adversary system. The vessel owners and their insurance companies are working against a crewman to defeat and minimize the amount of money they will have to pay in compensation for you. While you are recovering from your injuries, the insurance company's representatives are building a case against you. They may be talking to your doctors and gathering statements from witnesses. Modifications and changes may be made to equipment involved in your accident. To level the playing field, an injured seaman needs an experienced Jones Act injury lawyer who understands the nature of your injury and the fair value of your claim. If the insurance company or your employer is telling you that you don't need a lawyer, in most cases it is a sure sign that you do need legal representation. We are one of the nation's most experienced maritime injury law firms. The firm's background and experience allow them a unique connection with their clients. Our attorneys understand you, and they understand the jobs you do working aboard ship, tugs, and fishing vessels. Our attorneys know how serious injury accidents will impact you and your family for the rest of your life. When they tell you they think you have a good case, you can be confident that the opinion is based upon years of experience in handling Jones Act injury claims. Our partners have over 80 years of combined experience representing injured maritime workers. Millions recovered from injured fishermen and seamen. The Jones Act is a fault-based system. To recover under the Jones Act, an injured seaman must establish that he was injured as a result of his employer's negligence or the negligence of a fellow crewman. An injured seaman is entitled to claim damages under the Jones Act for pain and suffering, lost past and future wages, lost wage earning, past and future medical expenses, vocational retraining costs, and more. Pre-existing medical condition and comparative fault do not bar a seaman's claim for damages under the Jones Act. Proving negligence under the Jones Act requires only a slight connection between the negligence and the crewman's injury. Injured seamen also have the right under federal maritime law to make claims for maintenance and cure benefits. The maintenance and cure doctrine is a no-fault system that works together with the Jones Act to require an employer to pay an injured seaman's reasonable and necessary medical expenses related to a shipboard injury or illness. Under the maintenance and cure doctrine, a seaman is also entitled to payment of a daily living allowance while he is recovering from his injuries. If you have been injured while working aboard a ship, tug, ferry, fishing boat, or construction barge, it is important that you fully understand your rights under federal maritime law and also the Jones Act. Through and Bird LLC offers free initial consultations. Please contact us to discuss your claim by calling us, or you can sending a message online. You can trust us to protect your rights under the Jones Act and to get your fair compensation for the injuries that you have suffered. Thank you so much for watching. Don't forget to like, comment, and subscribe.